For Creamer Media's Polity, I'm Sane Dhlamini. Researcher and analyst Professor Raymond Suttner joins me for Suttner's View, a weekly commentary on South Africa's political scene. Welcome, Professor.
Thank you.
What do you think the chances are of the NPA appeal against the reinstatement of the charges against the president succeeding?
Well, from what I can see, first of all, the charges should not have been dropped in 2009, and the North Gauteng High Court gave a full bench decision which set that aside and reinstated the charges. So any appeal is an appeal against what three judges have found. And if you look at what the NPA is arguing, it's actually very weak arguments. In fact, it's not clear at all what basis they have got for appealing. The head of the NPA said, or the NPA argument is basically that the discretion to withdraw charges was an absolute discretion in the hands of the head of the National Directorate of Prosecutions, so that a court can't interfere with that because it's in the public interest for that discretion to be in the hands of the head of the NPA. Now that can't be, because judges have got the right to examine whether a decision has been made on a rational basis or not, and they found in the North Gauteng High Court that the reasons given for withdrawing the prosecution were not rational. There was not a connection between the interference in the process of prosecuting and the decision that was made. So they set it aside. And when they argue that this is an infringement of separation of powers, I can't understand how this can be the case, because first of all, unlike what they say, they refer to the NDPP as part of the executive. They're not part of the executive, as Pierre de Vos pointed out. They are supposed to be independent, and that independence is safeguarded, amongst other things, by the courts monitoring decisions in appropriate cases. So it seems very hard. Also, they asked the head, Mr. Abrams, who he had consulted, and he said he consulted a lot of counsel, junior and senior counsel. And they asked him, did you consult the counsel who had prosecuted the case originally, Billy Down? And he said no, he hadn't. So he was very selective in who he had consulted. Also, another problem with this case is that they may well refuse leave to appeal, because when they look at the grounds for appeal, they may say to themselves, look, these are not grounds. No court will find in a different way on the basis of these arguments. And they will then have to petition the Supreme Court of Appeal. Now, one of these courts is likely to let them come there, either through granting the appeal initially or through a petition. But when they get to the Supreme Court of Appeal, they face up to a situation where the Supreme Court of Appeal has already made decisions which count against the argument that the NPA is making. For example, they set aside the decision not to prosecute General Dhlamini, and they reinstated the prosecution. Now, there are a number of these cases that have already been decided which are in line with the decision of the North Gauteng High Court. And Pierre de Vos points out, not only the Supreme Court of Appeal, the Constitutional Court has made a lot of decisions which in order to accept the arguments of the NPA, they would have to reverse all those previous decisions. Now, there is no persuasive argument by the NPA to justify changes of that sort. Now, in the press conference, Karen Morn of ENCA asked Sean Abrams, in the light of the decision on Dhlamini, how do you reconcile what you're arguing? And it took a long time to answer, and then his answer was the facts are different or some such thing, and then he sat down. He hadn't really argued it. So one gets the impression that it's not a very convincing ground for appeal. For example, the grounds in other cases, like even though they are likely to lose or have lost some of these cases, the grounds have been very well prepared. This one doesn't seem to be well prepared. And in any case, there's no real case. So the likelihood, I think what one has to ask oneself is, if it is so weak, why are they pursuing it? And the answer is not legal. It is that they don't really want to prosecute the president. If they can avoid it, they'd like it to happen after they retire or after he retires, and they want to spin this out as much as possible.
And why do you refer to the separation of powers as infringed? Are they repeating political arguments of the ANC?
You see, I don't understand how it can be applicable here, because the executive is not coming into play here, and in any case, even if we were referring to the power of a minister or parliament, where that power is exercised in a way that exceeds what is constitutionally or legally permissible, well, then the courts are entitled to intervene. So that I don't understand what basis there is for arguing that the separation of... He's saying, what the court should have done is referred the matter back to the Director of Public Prosecutions to make a decision, not have reinstated them. But you see, what the court said is the decision to remove the charges was invalid. Now, if something is made invalid, you go back to where you were before. In other words, the charges remain. And there is no argument for a generalized permission to, in the interests of the public interest, to withdraw charges or not withdraw charges. What does public interest mean? It can be very politicized, and it will itself be a danger to the independence of the prosecutorial function, and independence which is already coming under pressure at the moment.
Thank you, Professor.
Thank you.
That was Professor Raymond Suttner speaking to Crima Media's Polity about the NPA appeal against reinstatement of Zuma charges.